Hello everyone and welcome to this Austmine webinar. I'm Sheldon Varco, the Membership Manager in New South Wales and South Australia here at Austmine, and I'm pleased to be joined today by Dr. Mary Turonek, Principal Patent and Trademark Attorney at Wrays, to explore R&D projects and IP governance. Before we begin, I would like to acknowledge that I'm hosting this webinar from the lands of the Gadigal people. I also acknowledge the traditional custodians of the various lands on which you all work today and the Aboriginal and Torres Strait Islander people attending this webinar. The presentation today will provide a need-to-know IP guide for the METS sector, looking at why you need to include IP in your project planning process, how to identify and mitigate project risk, and how to identify IP elements in your project, and more. Mary is a leading expert in the IP field and in the last 20 years has acted for startups, SMEs, universities, research organisations, ASX-listed companies and global multinationals with a diverse range of chemical and engineering related technologies, in particular in the mining, mineral processing, oil and gas and energy sectors. Following Mary's presentation, there will be an opportunity for audience Q&A. You can use the Q&A button at the bottom of your screen to send your questions over at any time. You can also upvote on the questions that you most want answered. So without further ado, I'd now like to hand over to Mary for her presentation. Welcome, Mary.
Yeah, thanks for the introduction, Sheldon. And thanks also to everyone for joining me in this discussion about R&D projects and IP governance. So governance is a term that we'd normally associate with the role and responsibility of a company board. And while it's true that a board plays a crucial role in IP governance in relation to the use, management and protection of a company's IP, in this webinar, what I really wanted to do is bring some clarity to some specific IP issues that a team needs to get to grips with when it's embarking on a new R&D project. So today I'll be talking about the various elements of an IP governance framework and why it's important to embed this framework into your planning and execution of an R&D project. Firstly, there are several compelling reasons to do so. And along the course of this webinar, without mentioning any names, I'll talk about some of my own war stories. Then I'll discuss the elements of the framework using IP as part of the planning process, identifying and mitigating risk, and that's one of the most important elements of the IP governance. Identifying IP elements in an R&D project, and this is effectively an audit exercise in identifying assets that the company may be using or creating. I'll also look at how to identify inventors or creators of the IP assets. And that really goes to the root of IP ownership. And finally, I'll provide some brief comments on IP strategy. Well, why do we bother about IP in R&D projects at all? And look, I get it after, over 20 years in the profession that companies are busy and IP can be low on the list of the priorities. But an early understanding of the patent landscape can be enormously helpful in the early stages of planning an R&D project. There is a vast amount of information available in the global patent database, and the solution to your problem, or some of the solutions, may well have already been invented. There is no guarantee that an R&D project is going to be successful, that it's going to run to schedule and that it's going to run to budget. So it's well worthwhile investigating at the very early stages what existing information is already available in the public domain. And I'll give you some tips on that in just a minute. Another compelling reason to consider IP issues at the outset is to avoid infringing third-party IP rights. This is a clear and present danger for every project. I've seen it, and frankly, I don't want to see it again with clients here in Perth. It's enormously costly, in terms of man hours, money, and sleepless nights. And I'll tell that story in a little bit more detail soon. But there's a multitude of other commercial benefits for a company when IP issues are properly managed. There'll be greater value created for the business, and not just from the view of the value of the IP assets in themselves and holding a competitive advantage because you hold a monopoly in those particular rights. The one company that I worked with years ago told me very early when they first engaged me that they had no intention of ever enforcing their patent rights. Frankly, they just didn't have their resources to launch litigation, etc. But what they did want to do was to create an IP portfolio as a marketing tool. They were a small company entering a market with much larger players, and they saw a fast track to gain credibility in the industry by promoting themselves as an innovative player with small volume, medium volume processing technologies. And they regarded their patent portfolio as a badge of their unique market offering. And so did their investors in the end. And they became $1 billion market cap company on the basis of commercializing their technology in the US. And their IP assets played an enormously important role in the growth and development of that company. The IP assets can also be used as bargaining tools. I've been involved with mining companies that have brought IP assets to the table as part of joint venture negotiations. One party brings the capital and the other party brings the know-how and the smarts. So, armed with all these compelling reasons, how do we integrate IP as part of the planning process? Well, firstly, as I mentioned before, at the outset of an R&D project, it's very useful to assess the competitive landscape and provide a technology landscape and where your technology wants to sit within that landscape. And indeed, is there any white space in which it can sit? And much of this assessment will probably already have been done and was the prompt for the R&D project in the first place. But the last two slides on this slide are often neglected. Look back to see what has already been created in-house. And don't just look at what's been done recently, look what has been done in the past and be cognizant of failed projects as well and why they didn't work. Be aware also of any aspects that have already been created by third parties. Is this technology that you are already licensed to use? Or is there third-party technology available that is free to use? Now, I think most businesses think that there's going to be a cost involved in using third-party technology. And that's true where the third party has enforceable rights in the country where you want to operate. But what I'd also like to emphasise is that there is an enormous amount of technical information found only in patents, which may be free to use. So not every company that holds a US patent for technology will hold a corresponding patent in Australia. Not every company that holds a Chinese patent for technology will hold a corresponding patent in Australia for that technology. In the IP world, Australia is regarded as a second-tier country. And what that means is that patent owners are more likely to file their patents in the US, in China, in Europe and Japan, and only some of their patents in Australia. So Australian R&D teams should really take advantage of the information that is available through online databases and try to extract solutions if they are there as part of their R&D planning process. Of the sites that I've listed on this slide, the European Patent Office is particularly valuable because it also includes Japanese, Chinese and Korean patents. There are tens of millions of patents in this particular database. And the European Patent Office has developed an excellent translation system. So the access to patent information that was printed and published in Chinese, Japanese, Korean is very easily accessible. So I really urge you to have a look and explore them. The sites are generally easy to navigate, and it's possible to construct a patent landscape around your particular project. Some useful search terms include the applicant or patentee name, which you would use if you were following a competitor's activities, the inventor name, if you knew of an individual who was active in that particular field, and you can also use keywords in the title, abstract claims, and indeed the patent description as well. But sometimes your use of keywords can be a bit limiting because, you know, not everybody may use those keywords consistently, and the use of those keywords may change over time. So, I mean, these databases with information will stretch over decades, and a keyword which might have been in use 20 years ago is no longer in use today, or not so, hasn't such currency. So I've also put a tab up here about international patent classification codes, or IPC codes as they're known, and they are codes that every patent is issued with when they are filed, and they basically relate to particular fields of technology that the patent is concerned with, and typically several codes are assigned to a patent. So it's a very useful method of broadly capturing patent data outside of the specific keywords that you may be using. It's a good fallback position to take. And look, if a patent landscape search becomes too big to handle, you can always call on your patent attorney to assist and sort the wheat from the chaff. Using third-party IP doesn't come without risks, and it's important to identify and mitigate the risk. That, as I said before, is an important element of a governance framework. I'm going to talk about risk from a patent viewpoint here, but many of the basic principles are the same for other IP rights because in the main, they are an exclusive right, and so the same scope of monopoly applies. So when we consider patent infringement, that occurs when a third party uses an invention that's the subject of the patent without the authorization of the patent owner. Now, before you can say that you're infringing a patent, there are a few criteria to tick off first. Firstly, the patent has to be in force. If the patent has expired, for example, then the inventions that are subject of that patent are free for all to use, regardless of where they were originally granted. Secondly, the patent has to be in force in the country where that technology is being used. So a granted patent that is in force in the US does not have any extraterritorial reach into Australia. So in the absence of a corresponding Australian patent, the invention could potentially be used in Australia without any risk of patent infringement. Thirdly, a patent is infringed when what you are doing falls within the scope of the patent claims. Now, many people make the mistake of reading a patent and thinking that they will infringe it because it describes part of what they're doing or all of what they're doing and what they intend to do. Now, while the description in the patent provides a lot of information about the invention and provides it with some context, the scope of the monopoly for that invention is limited by the claims of the patent. And the claims might actually capture a narrower scope than what is described in the specification. So you may well fall outside, what you intend to do may well fall outside the scope of the claims. Or alternatively, the claims could be broader than what's described in the specification. And while you don't necessarily replicate what's been described in that patent, you may still fall within the scope of that claims. So if what you are doing or intend to do does fall within the scope of the claims of the patent, then those consequences pose a real risk to your business. Years ago, I was working for an engineering company in West Perth, and they were specialists in offshore equipment. They designed and built a couple of big pieces of kit, which were very innovative and used offshore. They knew the Australian market well, and they knew that they didn't have any commercial competitors in that particular space. They were the only company doing what they were doing. So they thought they were pretty safe as far as infringing third-party IP rights. So they set about marketing their innovations, and one of their senior engineers gave a talk at an international conference. Attending this conference were two engineers from a Norwegian company which was operating out of the North Sea. A few weeks later, my client received a letter alleging that its piece of kit was infringing 2 Australian patent applications owned by the Norwegian company for the same technology. Now, in this case, it didn't matter that the Norwegian company had never built or operated what was the subject of those patents. They hadn't built them or operated them in Norway or anywhere else. What mattered was that my client had already sold, operated, and had a maintenance contract for a piece of kit from which over the past 4 years, it had earned multi-million-dollar revenues, and that it was now looking at it being potentially liable for patent infringement, and that multi-million-dollar revenue was at risk for damages or an account of profits. Now, as you can imagine, this led to many sleepless nights, a risk that the company might go out of business, plenty of legal fees to sort out, and a huge distraction to the company management to deal with this issue. Look, it got sorted out in the end, but it's a good example of how this problem, it is a real and present danger, even in a market where you think what you are doing is unique. And the way to mitigate this risk is to perform freedom to operate searches early. I can't emphasize that enough. These are specialized searches that are best performed by patent attorneys who can interpret patent claims correctly. The searches need to be specific to the countries where you're going to be active. So there's no point running a freedom to operate search in the US if you're not going to be exporting your goods or your services to the US. If you're going to only be operational in Australia, then you need to focus that freedom to operate search on the Australian Patent Register. They need to be performed periodically, so you need to update those searches every 6 months, and that's because the patent landscape is dynamic and changes over time. But freedom to operate searches are not the be-all and end-all. As part of a good governance framework, you're going to have other checks and balances to mitigate other risks of IP infringement. Firstly, complete an IP audit and put some clarity around the IP assets you are using and will be using. Be certain about which IP elements were developed in-house and which IP elements are from third parties. And for those that are owned by third parties, establish whether you have authorization to use third-party IP or whether you still need that authorization. If you're going to use licensed third-party IP for a new R&D project, and this is technology I'm talking about that you've previously licensed already, read and comply with the terms and conditions for use of that licensed IP, and check whether you can use it for new projects or whether there are any restrictions on the use. Find out whether you have to renegotiate the license. Last year, SPC got into a lot of trouble for continuing to use software that their predecessor in business had sold them. They failed to renegotiate with the licensee and obtain a license to use this software to do what they wanted to do. Effectively, they were operating without a license, and they got their wrists soundly slapped with damages and damages from that copyright case. It's also important to document which personnel are key contributors to any IP developed in-house, especially now after this recent High Court decision concerning whether contractors are contractors or actually employees. Pay particular attention to the involvement of contractors and subcontractors who are involved in the R&D project. And don't just assume any longer that an employee is an employee. They might just be a long-standing contractor. So it's important to document each person's contributions over the course of the R&D project. And if it looks like new IP has been created, then put in place some agreements or assignments with the contributors to clarify the ownership of the IP, and do it at the time the IP is created. The last thing you want is for a third party to put their hand up in the future and claim ownership or part ownership or entitlement to the IP rights that you've previously claimed as your own and have been the subject of agreements and contracts with your customers and clients. Now, I've touched on collaboration with third parties, and I know that this is a subject that vexes a lot of people. And look, I'm not going to tell you that the IP issues associated with collaboration are easy to navigate. There's no one-page agreement that is going to cover all the issues. From my point of view, successful collaboration is about setting out the ground rules of engagement at the beginning, thinking ahead to what you want to happen during the project, but also what you want to happen after the project, and building that into the collaboration agreement. And particularly building in contingencies that have already been planned for when the collaboration doesn't go as planned. So I'm going to spend a bit of time on these checklists, and they are by no means exhaustive, but they provide part of a scaffold to deal with IP issues arising out of a collaboration. Now, look, right at the beginning, everyone is nervous about sharing ideas and information. Confidential disclosure agreements are essential. And remember, you only need to share what the other party needs to know at any particular stage. You don't have to give them everything all at once. You can stage the transfer of information to that third party. Additionally, I think you also have to make a risk assessment about the information. And if it is too valuable to transfer to a third party, you have to make that call. Or transfer it in a way where the value isn't exposed. But it is a call each and every time that you have to make. And as much as you can mitigate with confidential disclosure agreements, there is always that inherent risk in making the disclosure that the agreement will be breached. Look, I think it's also important to be upfront if, as a receiver of confidential information, you already knew this information, or the information had already been disclosed previously by another source. You need to let the other party know that immediately, not 6 months down the track of, oh, well, we knew all about that. You know, that's not an issue. You need to be transparent about what you already know with respect to the third party confidential information. And I can't emphasize enough, document exactly what information has been disclosed by each party, which drawings have been exchanged, and so forth. You know, who was it disclosed to? When was it disclosed? And any limitations on its use, such as, you know, only for the eyes of X, Y, and Z, or only for the purposes of this discussion to explore a collaboration. If you then travel further down the path of collaboration, document and clarify the extent of the background IP contributed to the project by each party up front. And you can't go wrong by putting in as much detail as possible. you absolutely must know what each party is bringing to the table. This is your starting point. You'll need to know whether what you develop as a result of that collaboration is an improvement of your background IP or their background IP. You'll need to know how the project uses the background IP and whether you still need to rely on some elements or all of that background IP at the end of the project in order to use what's come out of the project. So having some clarity about what that background IP is really important upfront. And obtain at the time confirmation that those third parties either own the IP that they're going to contribute or have the necessary authorization to use it. And check whether it's encumbered by anything arising from previous collaborations. And that's particularly the case for universities and research organisations that routinely work with private sector or industry partners. You need to know whether you'll be using third-party IP that's been developed previously in partnership with a competitor. And the flip side of that is you'll need to guard against, IP and improvements to the background IP of being used by one of your competitors in the future when they collaborate in their next research project with an industry partner. So these are all really important things to consider. And I think, trying to foresee them up front and get clarity up front is absolutely essential. Throughout the course of the project, document all stages of the R&D and note individuals' contributions at that time. So it's important to keep track of this because the chain of entitlement to the owner of the IP is derived from the inventors or the creators of that IP. So as I said previously, make sure assignments of the IP from the inventors or the authors are signed at the time the IP is created. As far as possible, try to have some clarity about the scope of the collaborative project and what activities will fall inside and outside the scope during and after the project is completed. And look, with all the best will in the world, we know that sometimes collaborations don't go to plan. So build contingency plans into the agreement up front to deal with a situation where milestones aren't reached, or somebody goes out of business, or somebody else is acquired, or a key person goes to work for somebody else. It's important to plan for what happens after the project is completed. What can each party do with the project IP after the project completion? And make sure that it's in line with the original intention at the outset of the R&D project. And, there are complaints, right at the beginning of projects. Everybody's keen and wanting to get going, and that they see these agreements as obstacles to holding back the progress of the project. But there are so many trips that each party can, fall over along the way and be left with very, very bitter taste in their mouth at the end of the project when they realise, well, they're not getting what they really wanted to get. So have a staged agreement where you set out the terms of engagement and what each party wants, memorandum of understanding, and then hopefully that will speed up any formal legal agreements, collaboration agreements between the parties right at the outset. But putting these good foundations in will stand you in good stead, even if they do take a little bit of time to get right. So we're next going to talk about identifying IP elements in an R&D project. And I'm sure you'll all be familiar with the concept that there may be multiple forms of IP in every project. But I just wanted to illustrate here how different IP rights protect different elements of the same product. So just in case you're not clear about the function of each particular IP right, a registered design would protect the shape and appearance of a product. So, I mean, theoretically, you could protect the whole appearance of that dump truck, but you could also protect components that are within it with a registered design, their shape and appearance. Functionality, though, is generally protected by a patent. So it doesn't really matter what it looks like, what dimensions it has, as long as it works in the same way and embodies the same inventive concept, then that's an invention protected by a patent. So there'll be licenses for third-party technologies, there's trade secrets and confidential information, copyright in software and manuals, IP ownership agreements is all part of the mix. And then from a marketing point of view, there'll be trademarks and domain names. When all of these elements are managed well, then they can really lead to an uptick in value of the new product on the market, above and beyond its value in the field. One thing I've noticed over the years, however, is that engineers in particular are their own worst enemy when it comes to recognising new IP in a project. They are, in my experience, far too quick to say that something is obvious. And that's often generated by the fact that they've taken some off-the-shelf technology, done something clever with it, but have decided that it was obvious to do what they've done. And look, I've got here a list of different indicators for inventiveness, but let's address this issue of using off-the-shelf proprietary technology. So a patentable invention has to be new and it has to be inventive. So the off-the-shelf proprietary technology that you use, that might not be new in itself, but if you configure it in a different manner or you combine it with new elements, by definition, that combination or configuration is going to be new. And if the combination or configuration solves a problem or provides an advantage, for example, it increases productivity or it reduces fuel consumption or it reduces carbon dioxide emissions, then more than likely it's an inventive combination too. So look, leave your modesty behind and let the patent attorneys advise you on whether the technology you've developed is patentable or not. All patent attorneys are either scientists or engineers. And look, there's nothing we enjoy more than learning about new technology and the problems that they're trying to address. So if you are in doubt about whether the outcome of your R&D project is patentable or not, then let them assist you. Call them in, sit at a round table, describe what you've got, and let them assess and assist you to identify the IP so that then you can make the decisions about how best to monetize it. And before I finish off on this section, one of the other best practical elements that you can use in your governance framework is an invention disclosure form. It's all very well to identify IP, but an invention disclosure form will help you to capture that IP as it is being developed. So a comprehensive invention disclosure form should list all the contributors to the invention, should list the problem that's trying to be solved, and provide a description of previous solutions or what's being currently used. And it should clearly identify what is different and why. The technology should be described in detail together with the results of any trials and experiments. Ideally, the invention disclosure should be accompanied by a patent landscape search, and any patents that have similar technology should be identified. There should also be a section which lists any publications or disclosures about the technology that have been performed recently, such as at conferences or trade shows. So develop a register of those invention disclosures so that they can be collated and set up a process to assess them and make a decision about what needs to be done in accordance with your business strategy and your IP strategy, and document the reasons why action was taken or not taken. So this leads me into a section about identifying inventors and why it's important to identify the inventors or the creators of IP. And the reason is, in the world of IP, the ownership of rights is derived from the inventors or the creators of the IP. So just because you paid for some research or paid a contractor, it doesn't mean that you own the IP. So the first step in establishing a chain of entitlement, and at the end of that chain is ownership. That's one of the reasons you need to identify the inventors or the creators. So look, I've noticed over the years that being named on a patent as an inventor is sometimes used as a reward for employees, or someone in senior management might even self-nominate themselves as an inventor because they own the business or run the department. Being named as an inventor is a matter of fact. You don't get to be named as an inventor just because you were on the team or provided the budget for the project. An inventor has to have made a material contribution to the invention, and some of the relevant questions to ask appear on the slide. In my experience, it's sometimes helpful to call in an independent assessor to interview the inventors, to review the invention disclosure agreements, and make an independent determination of who the inventors are. And that takes all the emotion and all the politics out of the decision. And again, get those timely assignment documents signed at the time that the inventors are there, because you don't want to 6 months, 12 months, 2 years down the track need to be able to show documentation of that chain of entitlement, and that inventor is now working for one of your competitors or disappeared off the face of the planet, or there's bad blood. Finally, I'd just like to say a few words about strategy. And Red Peters, CEO of Philips IP and Standards, said a few years ago that a business strategy without an IP strategy is no strategy. But then he also said an IP strategy not linked to the overall business strategy is not much of a strategy either. So what's the message here? That an IP strategy has to be interlinked with the business strategy to maximise the full value of the R&D project. Ideally, you have to have the IP strategy informing the business strategy and the business strategy informing the IP strategy in an endless loop. So legal, marketing, technical, operations and finance parts of the business, they all have to be talking to one another in relation to these elements. No two businesses are the same, so no two IP strategies are going to be the same, but there are common elements that each company is going to have to suit its commercial objectives. So in the next few slides, I'm just going to pose a few useful questions to consider when putting a strategy together. Firstly, what are the characteristics of the business? B2B, B2C, growth market, mature market, shrinking market, high or low barriers to entry, small players or only a few big ones. What's the position of the business in the market? Is its market share high, low, growing, shrinking, profitable, strong or weak IP position? Is it a technological leader, a follower, early adopter? Does it want to grow, stabilise, get out of the market? All of those answers are going to influence the IP strategy you'll adopt. Whether you develop IP internally, buy-in or license in third-party technology, or engage in collaborative or open innovation. You might even adopt a hybrid model where all of those elements are at play. And finally, when it's all over, are you set up to create value over and above the actual product or service? That's the outcome of the R&D project. Has your IP been identified, captured and managed so that you realise better value? Will you be able to use the IP to defend your market position for new products and services? Will you be able to license the technology out to providers and operators in countries where you won't be operating? There aren't any easy answers, and it can be complex and it can be challenging, but integrating elements of an IP governance plan into your R&D projects will better position you to take advantage of additional value in the assets you've created and minimise risk. So happy to hand over to Sheldon now and field any questions, and I'm always happy to field questions offline as well.
Wonderful. Thanks a lot for that, Mary. That was an excellent presentation. A great guide for METS businesses and full of good information there. So we really appreciate you sharing that. As Mary said there, we do have about 5 minutes left for audience Q&A, and we do have some ready to go, which is great. But if you do have any more questions, please pop them in the Q&A box now, or follow up with Austmine or Wrays after the webinar, and we can get you some answers on those. So Mary, I'll start off with a question here. So we're working on the question says we are working on an IP, in this instance, a measuring device, which the principle of measurement is just a general physics principle, but find other patents have already claimed that principle. Are we still able to register a new patent based on that same principle? Is that considered infringement?
Well, look, that's a question where the answer is only being, I can only provide the answer by providing the devil in the detail. You know, to answer your question about whether you infringe, we would have to make a direct comparison to what you're intending to do with the claims of the patent that you've identified. Whether your measuring principle could be patentable, it well could be patentable. If it contains or involves a feature which is novel and inventive over and above what's already been disclosed on the public record, it could well be patentable. But the paradox is that it could be patentable IP and it could be infringing IP at the same time. But happy to talk to you or offline about that, but it's not something that you can provide a definitive answer to.
Wonderful. Thanks, Mary. And yes, we will provide Mary's contact information in the follow-up email for this webinar, so you can get in touch directly with her. A question here from Christopher. So how does the timing of enforceability work? Could others start or even complete a design while using tech covered by your patent? But if they only start production after the day your patent has expired, would that be without penalty?
Yeah, look, your monopoly rights commence at, well, they don't commence. They sort of, it's a bit of a moving feast. When you file a pending patent application, okay, you file a complete patent application, and the patentability of your invention is assessed on the basis of any information that's in the public domain up to the earliest priority date of your patent application. So the patent application proceeds through examination and is ultimately granted. You don't have any monopoly rights in relation to your invention until the patent is granted. But those monopoly rights, the term of the monopoly rights, then date back to the filing date of your patent application. So you can take retrospective action against an infringer that has been possibly infringing your patent in a period of time before the patent was actually granted. But there's, in terms of enforcement issues, there are a few other details and steps that you can take or need to take that's a bit too complex to go into in this forum. But your monopoly commences from the time that your patent's granted, but it dates back retrospectively to the filing date of your patent.
Wonderful. We might finish off with this last question. As I said, we can get you some answers to the other questions following the webinar, but they are some IP has such general and broad claims that it does not leave much room for registering any new patent. For example, a patent claims that a probe on a medical device used for ultrasound diagnostics. Does that mean whoever comes up with an innovative design which involves a handheld probe, in this example, is infringing the original patent?
Yeah, look, potentially. As I said before, you can produce innovations in a field of technology where there are broad patents already existing, but at the same time, you may well be infringing the claims of that broader patent. And that's a very usual situation in the electronics industry, where different parties cross-license their patents to one another so that they can provide products to the market. And I think I mentioned cross-licensing possibilities on one of the slides, but it's a common scenario where parties hold different patents and yet they infringe each other's patents at the same time. So in order to move forward, they have to come together and give each other cross licenses to the technology.
Excellent. Well, thanks a lot for that, Mary. That was a fantastic session. As I said, for the audience, we will follow up later today with a copy of the recording and also some additional details and Mary's contact information. Mary, did you have any final things to say before we go?
No, I think I've said it all.
Wonderful.
Not at all, but
wonderful. Well, thanks a lot to you, Mary, and the team at Wrays. It's been a pleasure working with you. Thanks to everyone who's attended this webinar. Stay safe, and we'll see you next time. Thanks, everyone.
Thanks a lot. Bye.